everyone, welcome to Abhigyan Academy. Today we will discuss about a very important chapter, that is Supreme Court. Our judiciary is a very important aspect in our examination from the examination point of view. So we know that our judiciary is a integrated judiciary. Okay, what is integrated judiciary? That means we have Supreme Court as the apex court, that means at the top level, then High Court, and then lower courts. So this is an integrated system. If you are not satisfied with the verdict given by lower courts, you can always appeal in the High Court, and if you are not satisfied with the verdict of the High Court also, then you can appeal at the Supreme Court. That means it is integrated. It is integrated. It is tied in one system. Okay. So don't get confused. Central laws, that means parliamentary laws. Central laws plus state laws. Central laws as well as state laws, this will be looked by, if this gets violated, it is looked by our judiciary. That means this system. Okay, done. So, first point you have to remember, our judiciary is a integrated one. Integrated judiciary. Okay. Second point, our judiciary is what? Our judiciary is independent. Independent. What do you mean by independent? That means judiciary is independent of any executive or legislative interference. Legislative interference. That means government or parliament cannot intervene in the working of judiciary. Done. So 2 points you should remember: integrated as well as independent. Okay. Moving to the next slide. Before discussing this point, see this point. See, there are some points you need to remember. Points are, one second. Okay, fine. Function of Supreme Court. So we will first see the Supreme Court, then we'll move to the High Court. Okay. So function of Supreme Court. सुप्रीम कोर्ट का क्या फंक्शन है, क्या काम करते हैं सुप्रीम कोर्ट? फर्स्ट, सी सुप्रीम कोर्ट इज द गार्जियन ऑफ द कॉन्स्टिट्यूशन. सी वी हैव आवर कॉन्स्टिट्यूशन, right? We follow constitutional supremacy. That means constitution is at the top level. Government, parliament, neither judiciary. No one can override what's written in the constitution. That means we follow what? We follow constitutional supremacy. We follow constitutional supremacy. Constitutional supremacy. In India, we have our constitution, and every organ have to run according to what's written in the constitution. So constitution is at the topmost and at the supreme position. All right. But if some constitutional rights or some constitutional provisions has been violated by anyone, any organ, then who will check those? Who will check those? Who will give us justice? So it is the function and it is the work of Supreme Court to check whether our constitutional rights or constitutional values provisions have been violated or not. So we refer Supreme Court as the guardian of our constitution. Supreme Court protects the provision of the constitution if anyone violated them or if any citizen's rights has been violated. Okay. So protects constitution from any undesirable change. Then guarantor of the fundamental rights, we have Article 32. What Article 32 says? Article 32 says that sorry. Article 32 says that it gives constitutional remedies. What is constitutional remedies? That means if our fundamental rights got violated, who will protect them? We can directly move to the Supreme Court. Please remember this point. Question can be asked in this manner, that can we directly approach Supreme Court if our fundamental rights got violated? Yes, it is correct. You no need to go to the lower court first, then high court, then Supreme Court. No. If your fundamental rights if your fundamental rights got violated, you can directly go to the apex court, that is Supreme Court. And which article give us the power? Article 32 give us this power. So that means judiciary is protecting our fundamental rights, right? So number 2 point. Number 3 point, sole authority of resolving dispute in case of election of president, vice president. Who will decide? Dispute agar hua to, if election declared void, if some candidate elected by some fraud means, then also dispute can be arise, and those dispute will be resolved by our Supreme Court in consultation with the Election Commission of India. Okay, then any center state dispute happen, then also Supreme Court will look over that. Why? Because Supreme Court is the apex court, right? Center state dispute, meaning government of India, for example, government of Assam. If any dispute arises, then that dispute will be resolved by our Supreme Court. Okay? And highest court of appeal. Here it says highest court of appeal. That means Supreme Court is at the topmost level. We can appeal to that court also. That's why it is known as highest court of appeal. Okay? Highest court of appeal. Okay, now see these articles. Very important. Supreme Court related article from article 124 to 147, part 5 of our constitution. This says everything. That means organization, independence, jurisdiction, powers, procedures of the Supreme Court. Everything is mentioned in this article. Okay, in this article. Let's see article 124 now. See, before moving to the appointment process, we will first see the eligibility criteria. That if you want to become a judge in the Supreme Court of India, are you eligible? You should know the eligibility criteria, right? If any examination happens, first they provide us what? First they provide us the eligibility criteria. That means, are we eligible or not for that position? So, if you want to become a Supreme Court judge, Article 124 clause 2 says, Article 124 clause 2 says that, what it says? It says about the qualification. You have to be citizen of India first. Okay, you should be Indian citizen. Okay, it doesn't matter you got the citizenship by birth or by naturalization or by registration. It doesn't matter. But at the time of being eligible for the position of judge of Supreme Court, you has to be Indian citizen. Okay, and please remember, there is no minimum age limit. There is no minimum age limit. Nahi hai. Maximum age limit is there, and maximum age limit is 65 years of age. Okay, maximum. If you are 65 and above, you are not eligible. Okay, then this is first point. Second point, you has to be or has been for at least 5 years. आपको क्या होना है? High Court judge. For at least 5 years, you has to be working as a judge of High Court. 5 years, at least 5 plus. That means 5 years or 5 plus years. You have to be a judge in any of the High Court of India, in any of the state. Then third point, you has to be at least 10 years advocate of High Court. Here it is judge of High Court for 5 years or advocate for 10 years. Please remember this point. And number 4th point is also there. In the opinion of president, you has to be a distinguished jurist. What does it mean? What is distinguished jurist? That means you have contributed to some landmark judgment, or you have contributed your opinion and that has been proved right or very much appreciated regarding some of the important cases. Okay, you are very capable, you are very experienced in the field of law, then you can be considered as distinguished jurist, and it has to be considered by our president. Then also your name can be recommended for the position of judge of Supreme Court. So this 4 point you should remember, very important. Moving to the next slide. See this point. Article 124 clause 2 says CJI, our Chief Justice of India. Chief Justice of India. Who appoints what's Chief Justice? It is President. It is President. And who appoints the other judges of the Supreme Court and High Court? It is also the President. Please remember the point. In case of High Court also, it is President. You can be, there are chances you can be, you may get confused. Why? Because High Court, in the case of High Court, गवर्नर भी आपको लग सकता है, क्योंकि स्टेट में तो गवर्नर रहेगा, हाई कोर्ट तो स्टेट में रहता है, बट गवर्नर इज नॉट करेक्ट. In case of judges, Supreme Court as well as High Court, both are done by President of India, and Chief Justice is also appointed by our President of India. Okay, done this point? Okay. Then appointment. See how this appointment are done. So it's not like one day President wake up and says, yes, come here, you are now the Chief Justice of India. It's not like that. So what happens regarding the appointment of Chief Justice of India? See, first, there is a collegium system. Okay, there is a collegium system. What is collegium system? Collegium system means a group of people, a group of 5 people. Okay, those 5 people will recommend or will decide a name, and the name has been sent to the President of India, and then the President of India give his assent. Okay, so that is the collegium system. That means a group of judges. How many judges are there in our collegium system? There are 1 Chief Justice of India plus 4 other senior judge. All total 5 member. 5 member. Okay, our collegium system consists of this 5 member. This 5 member collegium will decide a name, and that name given to the President of India. That's how the appointment of the judges are done. They follow a seniority principle. What is seniority principle? Seniority principle means the name should be recommended on the basis of seniority. Okay, on the basis of seniority. Seniority doesn't mean the age. Okay, seniority means the experience. Okay, कि आपने कितने साल काम किए, उस हिसाब से क्या होगा, उस हिसाब से आपका नाम रिकमेंडेशन जा सकता है. Done. And that's how the appointment is done. In case of Chief Justice also, the collegium will decide who will become the next Chief Justice of India according to the seniority principle. Okay. Then see how this how this collegium system have been evolved. Okay, how this collegium system has been evolved. See, first we should remember about the 3 judges case. 3 judge case, first judge case, second judge case, and third judge case. Okay, and third judge case. What happens here? In the first judge case, see, when our constitution commenced, article 124 says, based on the seniority principle, you should what? Recommend names and appoint it as. Based on the seniority principle, President will appoint a name, okay, as the Chief Justice of India or as the Judge of Supreme Court. But what we have seen in the past years, that seniority principle has not been followed by the government. Okay, so government are recommending or suggesting names based on their convenience. Okay, so this first judge case arises. See what happens in the first judge case. It has been asked that if any names are recommended by the government or by the judges of the Supreme Court for the position of Chief Justice if this has to be followed by President or not. That means, please understand this. That means if any A, B, C, D name has been recommended to the President of India, it has been questioned that whether President will recommend that, President will appoint that name, and President का ये compulsory होगा नहीं, होगा क्या कि President has to sign that name as the Chief Justice or Judge. Is it binding on the President that President needs to follow that? President needs to follow that recommendation. Is it binding on the President? So question arises in the first judge case, and it has been decided in the first judge case. Yes, consultation. See, in the article, okay, in the article 124, it says President will appoint in consultation with the Chief Justice. Consultation with CJI. So, does this consultation means, is it binding on the President to give his assent? Is it binding? Okay, you got my point? Article 124 doesn't says that consultation means concurrence. That means whatever the name or whatever the suggestion given by the Chief Justice of India, that has to be followed by the President of India. Article 124 doesn't say that. That means it is not binding on the President. So, if government is favoring their people in the judiciary, is government is suggesting their people in the working of judiciary, then there will be interference of the government. And we know we are independent judiciary, we have independent judiciary. So, independence will be restricted. That means government will interfere, right? If government's representative are appointed as the judge and Chief Justice. So, here the question arises, what does this consultation means? So, in the first judge case, 1981, it says consultation does not mean concurrence. That means this is not binding on the President. So, President is independent to appoint anyone as the Chief Justice or Judge of Supreme Court. Why? Because in the first judge case, it says consultation does not mean concurrence. That means the opinion given by Chief Justice of India is not binding on the President. Simple. Is not binding on the President. See, CJI's opinion is not binding on the executive. Here, executive means President. And we know President act on the aid and advice of Prime Minister and his Council of Ministers, right? So, first judge case में वो हुआ. Coming to the second judge case में लेकिन बोल दिया CJI's opinion enjoys supremacy equal binding on the executive. See, just to ensure the independence of judiciary, it has been decided in the second judge case कि consultation means concurrence. That means whatever the suggestion or recommendation will be given by CJI, that will be binding on the President of India or on the executive. मानना ही होगा. Why? Because independent judiciary will decide that who will appoint as the next Chief Justice or Judge of Supreme Court. Okay, very clear. And they have given key. They have introduced collegium system, and they have said, say there will be a collegium, and the whatever the suggestion or recommendation or names will be given by the collegium system, executive will have to follow that recommendation or that suggestion. Okay, and finally in the third judge case, same इधर में बोला कि collegium system में यहाँ पे collegium system को extend किया गया and says कि it is not this collegium system should not be one single member body. So there are currently there are 5 judge, 1 Chief Justice and 4 senior most judges are there in the collegium system who recommend names to the President of India, and President has to give his assent. President को बस sign करना है. Okay, so got the point. Now this collegium system got very much criticism. Why? Because first of all, it is very opaque. Okay. Second, it is non-transparent. It is promoting nepotism, favoritism, okay, underrepresentation of women, underrepresentation of women. So see these points. See these points. So government and the system is realizing this collegium system is very much opaque. We don't know. This collegium will decide whose name. This collegium will recommend whose name next, right? We don't know how the appointment process is done. Okay, they will favor or they will recommend their relatives' name to the president. It may be done, it can be done, right? So there are some allegation on the collegium system that it is very non-transparent. We don't know, we general public don't know who will be appointed next. It is underrepresentation of women. Women didn't get participated or didn't get their participation in the higher judiciary. So there is the this problems. Nepotism is so much there. कि आपका पापा अगर सुप्रीम कोर्ट का जज है और कॉलेजियम में है, then he will obviously favor his son, right? So this is the problem. So government introduced this National Judicial Appointment Commission by 99th Amendment. 99 Constitutional Amendment government ने किया in 2014. गवर्नमेंट ने क्या किया? गवर्नमेंट ने बोला कि नहीं, we will introduce a alternative system regarding the appointment, that is National Judicial Appointment Commission, NJAC. This body will appoint, this body will do the appointment process. Okay, so इस body में कौन कौन रहेगा? एक तो CJI तो होगा ही, 2 judge of Supreme Court, central law minister, 2 civil society expert nominated by PM and leader of opposition. See this in the NJAC, you notice that here it consists of not only the members of judiciary, that means not only the judges, it includes the member of executive also. Central law minister will be there, and 2 civil society expert will also be there, nominated by PM. PM का representative होगा basically, and leader of opposition, right? So this will done the whole appointment process. But then judiciary again in the fourth judge case, judiciary declared this NJSC as unconstitutional. Unconstitutional. Why unconstitutional? Because it is violating what has been written in our constitution. It is violating the independence of judiciary. Violating or not? Because we are seeing the interference of this executive members, ministers. Okay, so that's why Supreme Court in the fourth judge case 2015 says this National Judicial Appointment Commission as unconstitutional and struck it down. Struck down. That means it is struck down. Okay, and again collegium system will be there. So right now we are following the same system, collegium system, while appointing the judges. Okay, while appointing the judges. Okay, how can we remove the judge? Okay, agar if judges of Supreme Court will violate the constitution or will do some crime, then what is the procedure through which we can remove them? There is a process, and that whole process is written where? In the Judges Inquiry Act 1968. Whole process. But our article says, Article 124 Clause 4 says that judges can be removed by President of India only. Of course, at the last, President will give his assent as remove. Okay, but the removal, there is a long removal process and it is very rigid. The process is very rigid and tough. Currently also there is controversy revolving around the removal of judge of Delhi High Court, Yashwant Verma. So his removal process is initiated in the parliament. Okay. So at the last, president will decide, not decide. I mean, president will give his signature. That's why it is written down. The president can remove the judge of High Court, but actual process is initiated where in the parliament. Okay, in the parliament. So Lok Sabha plus Rajya Sabha, Lok Sabha and Rajya Sabha in दोनों हाउस में, in both the houses, the removal resolution can be initiated. Okay, can be initiated. And please remember on the grounds, these two grounds only. On these two grounds only. One is proved misbehavior or incapacity. Other than these two grounds, judges cannot be removed. These two grounds, proved misbehavior or incapacity. And दोनों हाउस में initiate हो सकता है. And दोनों हाउस में after the inquiry, it has to be passed by special majority. Okay, special majority. 50% of total strength and 2/3 of present and voting. That has to be attained by both the houses separately. Lok Sabha special majority has to be passed. Rajya Sabha special majority has to be passed. Then only it will go to the president and president will give his sign. And that the judge is declared as removed. Okay. So that's how removal is done. Then these articles are also important. Types of jurisdiction. Types of jurisdiction means the authority or the territory or the limitation where the Supreme Court can exercise their power. Okay. So there is original jurisdiction under Article 131. Original jurisdiction under Article 131. So here it says if center plus state, if any dispute happen between these two, center and state, it will be looked by the Supreme Court of India under original jurisdiction. That means this dispute will not go to the High Court. Okay, it will directly go to the Supreme Court, and Supreme Court can hear such this dispute in their first instance. Okay, then if between state के बीच में, दो स्टेट के बीच में अगर डिस्प्यूट हुआ तो भी डायरेक्टली सुप्रीम कोर्ट विल हियर द dispute. Okay. Then we have the next type of jurisdiction, writ jurisdiction. We have discussed this regarding the protection of fundamental rights, Article 32. Under Article 32, you can directly go to the Supreme Court if your fundamental rights got violated. Then appellate jurisdiction. Appellate means appeal, through appeal. If any case through appeal goes to the Supreme Court, then Supreme Court will hear that such dispute in under the appellate jurisdiction. Okay. If there is interpretation of law, if there is substantive question of law, that means if High Court feels, okay, if High Court feels that Supreme Court should interpret the law better or Supreme Court can interpret the law better, then it is referred to the Supreme Court of India, okay, from the High Court. And substantive question of that means very important matter. High Court feels that Supreme Court interference here should be here. So then also under appellate jurisdiction, High Court can certify to the Supreme Court. Okay. Constitutional cases also, civil cases also, criminal cases also. Constitutional cases means if any provision of the Constitution are getting violated and it needs the interpretation of Supreme Court, because we know Constitution में बहुत कुछ define किया नहीं गया, right? Definition is not there in the Constitution, and then that definition has to be given by Supreme Court of India, right? So that is interpretation. Supreme Court is interpreting the Constitution. So if any such interpretation is required, then High Court will certify that case to the Supreme Court. In a civil cases also, civil cases means other than the criminal cases. That means regarding marriage dispute, regarding land inheritance dispute, property dispute, those are civil cases where heinous offenses are not involved. Okay, just some dispute. And the criminal cases, you know, rape, murder, heinous crimes. Okay, those are criminal cases. So all these three cases, High Court, in all these three cases, High Court can certify those cases to the Supreme Court of India under appellate jurisdiction. Got the point? Okay. Then advisory jurisdiction. This point is very important. Advisory jurisdiction under Article 143. This is also known as presidential reference. Please remember the point. Question may be asked or can be asked like presidential reference under which article? That is 143 only, and Supreme Court advisory jurisdiction. So here what happens is president in any matter can seek advice from Supreme Court of India. Okay, president can seek advice from Supreme Court of India. Okay, done. And in two cases, first case is what case? First cases is important legal or factual matter of public importance. Important matter of public importance. For example, in case of का citizenship का जो issue था, in that case, in that regarding that act, president uses this presidential reference and seek advice from Supreme Court of India. Okay, and in a number two case, in any pre-constitutional treaty, for example, let's take इंडिया का जो नेपाल के साथ ट्रीटी है, ओके, नेपाल के साथ जो ट्रीटी है और इंडिया पाकिस्तान, फॉर एग्जांपल इंडस वाटर ट्रीटी 1950 or any pre-constitutional treaty in that matter, in those two cases president can seek advice from Supreme Court of India. And in the first case, president may or may not, what it means may or may not. President, it is so the president of India, president may or may not give their advice. Done. And in the second case, sorry, president bola maine, Supreme Court may or may not give their advice to the president. Supreme Court can deny also to give advice to the president. Supreme Court can abstain from giving advice to the president. But in the second case, Supreme Court has to give advice to the president. It is binding on the president if president uses this presidential reference. In the second case, what the second case means? That means in any pre-constitutional treaty, regarding any pre-constitutional treaty, if president asks some question to the Supreme Court or asks advice from them, they have to give their advice. Please remember these 2 points. And it is never binding, not binding on the president. Very important points, these are asked in the question, in the exam. In both the cases, it is not binding on the president to follow their advice or not. प्रेसिडेंट के ऊपर है, प्रेसिडेंट नहीं भी मान सकते हैं एडवाइस, ठीक है, बट सुप्रीम कोर्ट के पास फर्स्ट केस में दे भी सकते हैं, मना भी कर सकते हैं, सेकंड केस में देना ही होगा. ओके, सो इंपॉर्टेंट वन, प्लीज रिमेंबर. देन आर्टिकल 142, आर्टिकल 142 सेज president has a special power that president can take any action, executive action, in order to do complete justice. So president can take up matter in their own, and if they feel that their interference is required, their action is required to solve such cases, president can do that using article 142. Okay, got the point? Okay. Then these two, remember this acting chief justice under article 126. कब आता है एक्टिंग चीफ जस्टिस? कब हो सकता है? इफ CJI is vacant, office of CJI is vacant. Okay, for example, कैसे vacant हो सकता है? Resignation दे दिया. If he died by some unfortunate death हो गया, right? Removed हो गया, then his position or his office will get vacant. Then there comes this role of acting chief justice. Name says na acting chief justice. If CJI is temporarily absent, for example, CJI is ill, CJI is out from India for some reason, vacation liya hai, right? In those cases, there will be acting Chief Justice. CJI is unable to perform his duty, okay, and this acting Chief Justice will be appointed by President. Then ad hoc judges. Ad hoc judges means temporary, okay, temporary judges. Temporary, Article 127. Article 127, temporary. Ad hoc judges. Okay, so when these ad hoc judges are appointed, if the workload of Supreme Court is very much, okay, if very much workload is there, then Chief Justice of India, CJI, can temporarily appoint some judges to reduce those workload, okay, for the better working of the Supreme Court. In that case, CJI can temporarily appoint High Court judge as the ad hoc judge. तो किसी भी हाई कोर्ट के जज को ad hoc जज मतलब टेम्पोररीली ला सकता है सुप्रीम कोर्ट का काम करने के लिए, ओके. And see the differences. Here the appointment is done by the president, and here the appointment will be done by the Chief Justice of India. But here president approval is required, and Chief Justice of that concerned High Court consent चाहिए होगा. For example, if Assam one Guwahati High Court judge is being called by the Chief Justice of India to work as the ad hoc judge in the Supreme Court for a period of, for example, 3 months, then the consent of Guwahati High Court Chief Justice is required along with the approval of President. Then CJI can appoint those judges as the ad hoc judge. Okay, I hope you got it. Then last one is the retired judges. President or Chief Justice of India, okay, Chief Justice of India, along with the approval of President of India, can ask someone who has previously been a judge of Supreme Court or High Court to serve as a judge of High Court. Okay, बुला सकता है. That means if the person gets retired, he is a retired judge, but he has done some excellent work in some certain cases while he is working, then in some important matters his opinion will be required, right? So in that case, Chief Justice of India can ask him or her to serve again, okay, with president approval as well as his approval, his consent. Okay, so this is all about the Supreme Court of India you need to know about. I will see you in my next video in the next class. Thank you for watching.